Joining us now in the Element Well studios, Aaron Rice, the director of the Mississippi Justice Institute. Aaron, always good to see you, my friend.
Yeah, thanks for having me on, Gerard.
So, we got so much going on, and with respect to this Dobbs decision overturning Roe v. Wade.
Yeah.
And it's just been a watershed of activity.
Yeah.
In the courts, in the states. Protests on both sides, celebration by the pro-life camp, and good grief, the pro-choice folks have really gone crazy.
Yeah.
But here in Mississippi, like other states, some other states, red states in particular, we had what are called trigger laws.
Yeah.
Which is something I never even heard of, honestly, until this case. And essentially, if I could set this up, that is a law that was enacted that is triggered, that would go into effect based on some other event. It's connected to some other event. In this case, the event was the decision on the Dobbs case. And I think what Mississippi's trigger law says is that abortion would be prohibited in the state. And there is some time between, as specified in the law, some time period between the decision, in this case the decision handed down by the Supreme Court, and the effective date of the trigger law.
Yep.
The Attorney General is responsible for certifying that and then notifying any organization, or I guess it could be anything, any person, if a trigger law that could be in violation of existing law based on the effectiveness of the effect, I should say, of the trigger law. Here we are. And it goes into effect tomorrow.
Yeah, it does. It does. And so the trigger law, I mean, it prohibits abortion except for in cases of the life of the mother or rape. And so that's what it was. But, again, I mean, going back to the broader picture is just that, state legislatures had their ability to legislate on this issue taken away by the U.S. Supreme Court in the Roe decision and its progeny, Casey and all those. And so, what you had was state legislatures saying, look, we can't legislate on this, but we know that there are efforts to overturn those decisions. And so we're going to go ahead and say what we would do if we're allowed to do it, or what we're going to do if we're allowed to do it. So in this case, the Mississippi's trigger law was passed, I believe, 7 years ago or maybe more.
Right.
And it wasn't passed because of Dobbs. Dobbs wasn't even being litigated at the time. It was just saying if Roe is ever overturned. And the reason the Attorney General is responsible for certifying that is because, if you had some opinion that came down from the U.S. Supreme Court that was maybe a little blurry, people didn't really know what exact effect it had, you wouldn't want to have laws going into effect. So you have the Attorney General responsible. In this case, we had a very clear ruling in Dobbs, but the Attorney General, Lynn Fitch, certifies and says, yes, this decision has overturned Roe and Casey and his progeny, and our trigger law would likely be upheld by the court. And so once that's certified, the trigger law goes into effect 10 days later. In this case, that's tomorrow. Of course, we had the lawsuit from Jackson Women's Health Organization that was trying to prevent that based on the Mississippi Constitution, and we can talk about that.
Yeah.
But just yesterday, the special chancellor that was overseeing that court challenge basically declined to issue what's called a preliminary injunction, which would have prevented the trigger law from going into effect while that lawsuit is litigated. So because there's not going to be a preliminary injunction, these trigger laws will, in fact, go into effect tomorrow.
So Rob McDuff, who's the longtime attorney representing the Jackson Women's Health Organization, also known as the Pink House, because that is the color literally of the building, of the structure in which abortions are performed. And so he argued that the trigger law is in conflict with a 1998 ruling, right?
Yeah.
And that was the basis. But the chancellor, so if I'm not mistaken, this deal goes to the Supreme Court. Supreme Court appoints a chancellor.
Yeah.
I'm not exactly sure what that is. What the heck's a chancellor?
A chancellor is just a type of judge who deals with equity lawsuits like this. And so it's not necessarily about civil, damages. And so it's just the type of judge that deals with a case like this. But in this case, we're dealing with the Mississippi Constitution. The arguments here are perfectly fine arguments for, the Pink House to be making, Rob McDuff to be making. He's a good attorney. These are all very valid arguments for them to be making. It's just a kind of weird situation. And so if you back up, a lot of people don't even realize that we have a Mississippi Constitution and that all 50 states have a Constitution.
Sure.
And so the way it works is that the federal Constitution really just sets the floor, and its Bill of Rights sets the floor of these are the rights that have to be protected in the states. The 14th Amendment is what incorporated those into the states, but says this is the floor. But every state has the right, if it wants to have greater protection of rights set forth in its state constitution. And so it is not, completely unfeasible that you could have a situation in which Roe is overturned. The federal government is saying, the Supreme Court is saying there's no federal right to an abortion, but then some state could be saying, but under our state constitution there is.
I got you.
So what you've had is that back in 1998, this actually was litigated to the Mississippi Supreme Court. The Mississippi Supreme Court did, in fact, say there was a state constitutional right to an abortion. We can discuss where that supposedly was located in the Constitution. It was not specifically enumerated in the Constitution, of course, just like with Roe in the federal Constitution. But that did happen in 1998. Now, what makes this interesting and kind of really very much a legal gray area is that Fordyce opinion, that's what the name of the case was, 1998 pro-choice Mississippi versus Fordyce. It relied very heavily on the Roe decision. So it was basically comparing Mississippi's Constitution to the federal Constitution and comparing what the Supreme Court did in Roe and basically saying we're going to do the same thing here. There wasn't a lot of exploration of what you would normally need to see to say this is a long-standing, a history and tradition of a right in Mississippi. The court looked at a few things. It looked at, for example, the fact that abortion at the time of Mississippi's 1890 Constitution had been ratified, that abortion was illegal, but not before quickening, which is when the fetus can move the baby and the womb can move. And so it basically looked at all that, but it really based it heavily on the Roe case. And so what you had Scott Stewart from the Attorney General's office arguing in court yesterday was that, look, there may be a case out there right now that says this under the Mississippi Constitution, abortion is a constitutional right, but it's not going to be that way for long. Roe has been overturned. When this gets up to the Mississippi Supreme Court, it's very unlikely that they are going to continue to uphold that Fordyce case. So because Roe has fallen, which was really the main basis of that Fordyce case, Fordyce is going to fall as well. And because we are pretty sure it's going to fall, you should not be issuing a preliminary injunction that prevents the state from enforcing its laws in the meantime until the Mississippi Supreme Court clarifies that.
Right. And as I recall, in my very rudimentary legal experience and knowledge just as a business person, there's certain standards that have to be met.
Absolutely.
In order for a judge to rule that an injunction should be
Absolutely.
ruled,
So
right.
this is what they're seeking here, what's called a preliminary injunction, which again means we haven't litigated this all the way, Judge, but while we're litigating it, don't let the defendant do this, or don't let this law go into effect while we're litigating it. And in order to get that, the main thing, you got to get four things, but the main thing you need to prove is the plaintiff. And I do this all the time in my cases, too. I attempt to prove these things. You try to prove that, number one, you are likely to prevail as the plaintiff. So you're saying, Judge, when this does get to the Mississippi Supreme Court, we're probably going to win. Yeah. So the judge kind of has to almost semi-litigate the case, or almost semi-decide the case, kind of predict the outcome of the case. Yeah. And then you have to show that you're going to suffer irreparable harm if an injunction is not granted in the meantime. Then you have to show that the harm you're going to suffer outweighs the harm the defendant, or in this case the state, would suffer under the preliminary injunction. Kind of here it would be the state's lack of an ability to enforce its own laws. And then lastly, you have to show that a preliminary injunction would be in the public interest. Yeah. And so here the chancellor looked at all that and said, number one, you're not likely to prevail, Pink House. You're likely to lose. I don't think the Mississippi Supreme Court is going to continue to uphold Fordyce, which I think is the correct prediction there. Mm-hmm. Number two, yes, the doctor, the clinic will suffer irreparable harm, because you're not going to be able to, you're going to have to shut your clinic down, and a lot of things are going to happen to, your patients, which you can portray as a harm to them, or your doctors and all that. Number three, I don't think the harm does outweigh the harm to the state if it's not allowed to enforce its laws in the meantime. And number four, that it's not in the public interest, right, because the state has an interest in enforcing this law. So
even in more straightforward cases, it's a very difficult standard.
Yeah, it is. It is.
Intentionally.
It is. You don't. If you're going to try to stop the state, from enforcing a law during the pendency of the lawsuit, you need to have a very good reason to do that, and be able to show the judge. Again, the main thing that you show is that you're likely to win. Yeah.
let's continue this discussion on the other side of the break.
Sounds good.
All right, we got Aaron Rice from the Mississippi Justice Institute in the Element Wealth Studio. Foreigner bumping us into this segment in the Element Wealth Studios. We've got Aaron Rice, the director of the Mississippi Justice Institute. So as it stands right now, we're just talking about the trigger law.
Yeah.
Goes into effect tomorrow.
It does. It does, in fact, go into effect tomorrow. And again, the in this lawsuit that we were just talking about, if the chancellor had granted the preliminary injunction, what we would have is a situation in which, the Mississippi legislature 7 years ago had passed and the governor had signed a trigger law that said if Roe is ever overturned, this is going to be the law of the land in Mississippi. And then Roe was overturned. But then, because of a state constitutional, in 1998 state constitutional decision, that law was temporarily stopped from going into effect until the Mississippi Supreme Court could decide, what the status of the state constitutional right was. That's what you would have had. And in fact, I would not have been surprised if the chancellor had granted the preliminary injunction. I'm not saying that the chancellor should have, but you could easily see a trial court chancellor saying, look, as things stand, this Fordyce opinion is good law, and so I'm just going to go with that and let the Mississippi Supreme Court clear it up. But again, I said this earlier, it's such a gray area here. It's such a kind of unusual case because you've got, yes, technically it's the law of the land right now, that Mississippi Supreme Court 1998 Fordyce opinion.
Yeah.
But it is, again, if you read the opinion, and lawyers who might have read the opinion will know what I'm talking about, it really was based very heavily on Roe. And so anybody who's doing this, chancellor doing what she's supposed to do, the special chancellor, and predicting kind of who's likely to prevail, I think I think she made the right decision that, in fact, the Pink House is unlikely to prevail here at the end of the day.
It makes sense.
Yeah.
And that seems like that once that box couldn't be checked, that pretty much ended it. Because the other standards are almost
they
don't really apply.
Exactly. I think the main one really is who's likely to win here. Because if you can't show you're likely to win, then why should you get a preliminary injunction?
Yeah.
And so, so now, the law will be in effect, and the lawsuit will continue to work its way up to the Mississippi Supreme Court. But another twist you could have in the story is that it could maybe never even get resolved by the Mississippi Supreme Court because technically the legislature could start the process of enacting a constitutional amendment to clarify that, no, there is not a right to an abortion under the Mississippi Constitution.
Yeah.
Because what you had in 1998 was the Mississippi Supreme Court, finding that there was a right that was not explicitly enumerated in the Constitution. And you could have the people come back and say, no, that is not the case. We're amending the Constitution to make clear that there is not a right to an abortion.
Here's a question. So what happens if the clinic just defies the law and continues to provide abortion?
Severe criminal penalties is what happens. So the trigger law that is going into effect makes it illegal for any person other than the mother to perform or assist in the performance of an abortion and can carry criminal penalties of a year up to 10 years in jail and fines and all of that. And so because the law is in effect, whether it later is overturned or not, right now it's in effect. So if somebody goes out, and again, those criminal penalties do not apply to the mother, but to anybody else who performs an abortion during that period of time, the law is in effect. And so, there would be criminal penalties.
I mean,
like, did that.
Literally, if it's suspected or reported, does law enforcement enter the facility with a warrant or something? Is that how that works?
I think it would unfold just like any other criminal, act in the state. Yeah.
Okay.
So, and I don't know exactly. We haven't been in this situation before. But I think it would be. It could be anything from somebody swearing out an affidavit and saying, this is happening in this clinic and it's illegal, and law enforcement getting a warrant and going in to find out. I think it would happen just like any other criminal we it would be investigated, and arrests could be made, and court cases and all of that.
Well, we haven't had this. I mean, we're in uncharted territory, as they say here. But there have been reports in other areas of the countries where clinics that do provide abortion services are saying, we're just going to defy it and keep doing it.
Yeah, that's interesting. I would, if I were their attorney, I would not, I don't know the laws in those states whether criminal penalties are associated with it like they are here in Mississippi, but I do think it would be a very dangerous thing for any medical professional to be trying to test the boundaries of the law, but particularly in Mississippi. Like I said, I know there are criminal penalties here, and so that would and now we also have a court has declined to grant a preliminary injunction, so everybody knows that this law is in effect starting tomorrow.
Wow, it's interesting. So possibly, we hope there's not any incident.
Yeah,
but it's kind of setting up that we might.
I doubt there would be some kind of big showdown over this. I think most medical professionals, you and I have discussed this. Abortion is going to be legal in other states.
Sure.
And I think what you're going to see is anybody who feels that passionately and strongly that they want to be providing abortions or supporting the provision of abortions is going to go set up in states where it's legal and try to attract people to travel to that state. I don't think most people or doctors or medical professionals would risk their license, risk their liberty, all of that to violate the state law. So, but it has been interesting, you and I discussed this too. I mean, a lot of the misinformation I've seen around, what these laws, the trigger law in Mississippi, means and what they mean in other states. I've seen a lot of talk about, this is going to prevent, miscarriage services. If the baby in the womb doesn't make it and you have to have what's technically an abortion to remove the baby, that would be illegal. That's not the case under Mississippi's trigger law or any state's trigger law. Ectopic pregnancies, if you've seen those, or talk about that would be illegal to treat that. That's again, Mississippi's law says, you can do it to save the life of the mother.
Right.
Well, those kind of pregnancies are a risk to the mother's life. You can't just leave that.
Sure.
And so, there's been a lot, I think, of just misinformation about what these laws mean, both in Mississippi and outside. Yeah.
It's almost as if the prospect of defiance by the clinics is more to make a political statement than it is anything else.
And I think too. I think they're going down swinging here. I think they know that this lawsuit, based on the old Fordyce opinion, is really a low probability, particularly with the makeup of the current Mississippi Supreme Court. So if you're predicting, and not that the chancellor was necessarily tasked with doing this, but as a court observer looking in, that old Fordyce opinion read very much like the old Roe decision, and it was, there's certain penumbras of rights that aren't mentioned in the Constitution but are nevertheless there. And again, you and I have talked about this too. There are such things as unenumerated rights. No beef with that, and we want that. But if you're going to claim that something is an unenumerated right, a right that exists but isn't listed in the Constitution, you need to be able to show that there's a long history and tradition of that right being rooted in the American experience, or here, in this case, the Mississippi experience. Yeah. And that would go back to English common law and all kind of things. And you really couldn't do that here. And so, but that decision, again, was it was not what you would call an originalist or textualist approach. It was very much, we care about the policy and we're going to force a way to get this policy that we want through the courts. And so even just as a pragmatic matter, I would find it very unlikely that the current Mississippi Supreme Court would ever write an opinion that looked anything like that 1998 Fordyce opinion. The judges that are on the court now are going to say, let's look at the Mississippi Constitution, let's read the words, what do they mean, let's look at the history in Mississippi. In fact, again, abortion was illegal in Mississippi at the time, that at least post-quickening. And it's hard to say that something is a right when it's illegal under certain circumstances.
Exactly. So you've seen a number of companies have announced that they intend to update their policies, their health benefits policies to cover not only abortions, but travel from a state where they are not allowed for their employees that live in those states to states where they are allowed. Might they be breaking any sort of laws or at risk of doing so if that's for a person in a state, an employee in a state?
Yeah, I think you could see that. It would depend on what certain state laws said.
Yeah.
And I don't believe that would, under Mississippi's current trigger law, that would happen. And so what I do think is going to happen is that I think we're going to see an escalation of this fight on both sides. The pro-life side, the pro-choice, pro-abortion side are both going to seek to kind of be at war with each other. So you could see states start banning travel, or you could see California saying we're not going to allow any state employee or or agencies to do any business in Mississippi because we don't like their abortion policy. Right. But likewise, you could see Mississippi say, or other states say, it's going to be a crime to assist in an abortion, even by funding it.
Right.
And again, that's not the case right now, I don't believe. But you're gonna have a lot of that's gonna have to percolate through the system and figure out what exactly is illegal under various state laws and what's not.
Yeah. You got to go? You want to hang around?
No, I can hang around.
Yeah, we got Aaron Rice will come out. I want to get to some other topics. We have great discussion about this one, and it's very timely and pertinent. But there's some other stuff we can talk about as well. We got Aaron Rice, the director of the Mississippi Justice Institute. We need to talk about the con laws again.
Yeah, for sure.
We'll be right back. Studios, Aaron Rice, the director of the Mississippi Justice Institute. So we clearly haven't seen the end of what I think will be a flurry of lawsuits. Do you not?
Absolutely. Absolutely. So I think we are going to we were talking about it kind of going into this break, but I think that this post-Roe landscape is going to be very litigious for a very long time, and not just litigious, but state legislatures, I mentioned kind of warring with each other. And so I think it's going to take a very long time to really settle into what's the new landscape and what does it really look like. So, but I mentioned this. I mean, I think, as you alluded to, I think you could see some states maybe try to ban travel to another state and say you can't go to another state to get an abortion. Now, Justice Kavanaugh addressed that in his concurrence and said, look, I don't think that would pass constitutional muster. There's a right to travel. So I don't think states are going to be able to stop you from doing that. I think he did that because he knows he was kind of showing that we would have the votes on the Supreme Court to stop that. So states don't even try, I think, is the message he was trying to send. But there was talk of that before the Kavanaugh concurrence in the Dobbs case. I don't know if I'm sure we could see that. So you could see some states say we're going to ban traveling to another state for an abortion. Again, you could see states like California saying we're going to ban, doing business with states that.
Well, they've already announced they're banning travel.
Yeah. Like state travel.
Yeah.
States. Yeah. We're not going to spend any state money. Right. And we've seen that over kind of the bathroom wars.
That's
and stuff
been
like
in
that.
place with voting rights as well.
Voting rights, bathroom fights in the past. We've seen this. So I think you'll see that again. But I think you're going to see states try various mechanisms to do what I would refer to as extraterritorial enforcement of state law.
Gotcha.
So, Alabama trying to enforce its state law in California, which I frankly don't think is a good situation for states to get into that. But I think it's going to a lot of people are not going to be able to resist the temptation to try to do that. You and I have talked about the importance of federalism.
Sure.
And, whether we agree with another state's policy or not, I think that we need to understand that this is the way America works, and that Mississippi has the right to make its laws that govern its people, and California has the right to make its laws.
It's the way we want it.
It is the way it was designed. It is the way we want it. And as you know, when it comes to abortion, it's a very contentious issue.
Yes.
Emotions are very high, and I think that we're going to see that. I think we're also going to see efforts on both sides to pass a federal ban or a federal codifying of Roe. So you're going to see people trying to get Congress to either make abortion legal in all 50 states, signed by the president, or Congress to ban abortion in all 50 states, signed by a different president. And one good thing I could see coming out of that is I could see, if Congress did that, the constitutional power it would be relying on would be the Commerce Clause power.
Right.
And you and I have talked about this when it was a vaccine mandate. The Mississippi Justice Institute helped litigate with the Attorney General's office. We helped file a lawsuit against the Biden administration's OSHA vaccine mandate, and we argued they didn't have the power under the Commerce Clause. And I think you would see here, the court is starting to put more limits on the Commerce Clause. And frankly, I think even liberal justices might be more inclined to start putting more teeth into limits on the Commerce Clause, because I could see either case, say that that Democrats were successful in codifying Roe and saying abortion is legal in all 50 states. I could see the Supreme Court striking that down and saying you don't have the power under the Commerce Clause to do that. There's a state issue. But frankly, even if it went the other way, if Republican Congress people and senators were successful in passing a ban on abortion, I think, the Supreme Court would do the same thing. And I think the liberal justices would be with the majority on that and saying you don't have the power under the Commerce Clause to do that. So that's one good thing we could see come out of it is put more teeth into the Commerce Clause. But all that to say, I think you're going to see fights at the federal level. You're going to see fights between the states. And it's going to take a long time for us to really settle out and see what are the laws in the various states and how do they interact with each other and what happened at the federal level.
The codifying Roe v. Wade is not a legal cinch. It's not a legislative cinch, for sure. There are lots of issues there, and those who want to, it's not just, hey, we just want to write a law that says that you have a right to an abortion. It's more than that. It's got to rely on certain aspects of existing law, in particular the Constitution. So they're looking at the 9th Amendment, the 14th Amendment.
And the Commerce Clause, again, because people forget this. You and I have talked about this before. I mean, the federal government is a limited government.
Right.
And it's set out that way in the Constitution. And it says, the Constitution says, that for the federal government to do anything, it has to be able to point to a power in the U.S. Constitution that it has, where the Constitution gives it the power to do that. Now, the states, by contrast, do not have to do that. State governments have plenary authority, is what it's called, and they can say, we don't have to point to anything in the U.S. or Mississippi Constitution to show that we have the power to act here. We have inherent what's called police power, the ability to pass laws for the health, safety, welfare, and morals of our people. And the federal government cannot do that. And so here, what the federal government would have to do is point to the Commerce Clause, which, if you look at the Commerce Clause, it was originally designed at the time of the U.S. Constitution was adopted to prevent the states from getting into trade wars with each other. We had been under the Articles of Confederation. That hadn't really worked out. You had a lot of trade wars between the states. So the Commerce Clause was supposed to say Congress has the ability to regulate interstate commerce to prevent kind of trade barriers, trade restrictions between the states. That's what it was intended for. So to carry that over and say that somehow that grants the federal government the right to regulate for all 50 states on a topic of health and safety and welfare and morals is really a stretch.
Stretch at best.
It is. Now, the problem is that this is one of the reasons we've seen the federal government grow just as horrendously as it has and gotten out of all proportion to what it was intended to be under the U.S. Constitution, is that the U.S. Supreme Court has stretched the Commerce Clause for decades and decades and decades and said, well, this is okay, too much. This is okay, this is okay, this is okay. So we're getting to a point where there's got to be some hard limits on it. Now, actually, under the Obamacare decision, if you remember that put some limits on it. This vaccine mandate case that the Mississippi Justice Institute was a part of put some more limits on the Commerce Clause. So we're starting to see that it hit its outer limits and hopefully start getting pushed back the other direction.
It's the catch-all is what's really happened.
Absolutely. It was used as a kind of backdoor to be able to allow the federal government to do things that it was never intended to do.
And so let's be clear. You'd have to have either 60 votes in the Senate or a filibuster-proof Senate to codify.
Yes.
And Aaron, if they did, it's back in the Supreme Court.
No, absolutely, it would be challenged into the Supreme Court. And on the topic of the filibuster too, I think we talked about abortion being a very contentious issue, but I think you're seeing calls on the Democrat side to get rid of the filibuster. Now, if you remember, they already did that when it came to judicial nominations. Way back in the day.
We talked about it.
Absolutely.
Harry Reid.
Yes. And then when Republicans took over, Mitch McConnell had warned them and said, if you do it, we're going to expand that to include Supreme Court nominations too. And they did.
And Trump got his Supreme Court judges,
it led to the court we have now that Democrats are so upset about. So I think everybody needs to take a step back and say we don't need to start changing the way our institutions function. We don't need a court pack. We don't need to get rid of the filibuster. Let's just take a breath and try to govern with the existing institutions we have. But it's hard for people to do that on this topic.
I agree, but we hadn't seen or heard the last of this. All right, give me a quick update on your case.
Yeah, we're talking about the certificate of need case. Yeah, it's you and I have talked about this before too. There's a lengthy period after you get past the motion to dismiss of just discovery is what it's called, where you retain expert witnesses, you work with them, you exchange reports with each other, and then you start deposing witnesses and all of that. And so we're in that phase. It's going to be a good while. I'd tell you that it's probably going to be a year before we have a trial court opinion.
Okay.
And in the meantime, we already talked about preliminary injunctions at the beginning of this when it came to abortion. We are not seeking a preliminary injunction in this case for various reasons. And so while we're litigating, the con law is still in effect. And of course, our client is not allowed to go out and help Mississippians with his, home health service that he wants to start. That would be a great boon. I mean, especially to people in Jackson where he's trying to do this, to have another home health operator would be great for them. But he can't do that under the current law. And so right now we're continuing to just march forward with the case, press forward with the case, marshal our evidence and get ready to do all of that. And at some point we will, either have a trial or something similar to a trial, kind of a trial on paper is what you could envision it as. And hopefully the judge in the case would side with us. I honestly think we'll probably see appeals there too. You never know, but we could see appeals there too. So the fight will probably go on for a good while. As it stands, the con law in Mississippi is on the books, and we're continuing our legal challenge trying to change that in Mississippi.
We're wishing you luck with
Absolutely.
it. You know how I have strong feelings about that interfering with the market.
Yeah.
I just can't get on board with it.
Yeah, you've been a great advocate. And that's one thing that needs to happen too, is that we're marching through the courts. We're trying to do what we can there, but our legislators need to understand the bad impacts of this. The citizens of Mississippi need to understand. So I'm glad to have other voices doing the same thing.
Appreciate your work on that, and appreciate you coming in today.
Yeah,
Aaron.
sure
Very
thing.
informative. Always a interesting and good discussion. Appreciate it.
Appreciate it, Gerard.
Aaron Rice, the director of the Mississippi Justice Institute, has been in the